So now that we have examined what are the hierarchy of courts as designated under the Commercial Courts Act, comes the very important question of what is the procedure going forward? How do I file my claim? How is my claim adjudicated upon? So the very first step that I need to take if I am a plaintiff in a certain proceeding or a claimant in a particular proceeding is to file my suit. Now, when I have to file my suit, there are certain rules of procedure of Code of Civil Procedure that apply. There are also rules of procedure of various high courts that apply. While we are not going to examine that in detail for the purposes of this session, while filing your plaint in whichever court you do file it, it is always appropriate and it is recommended that you go through the rules of procedure of that court as well. So the process starts with the filing of a suit. I file my suit on day 1 as the plaintiff. The court lists the matter for hearing. When the matter is heard for the first time, the court issues, if the court believes that there is some merit in your matter, the court issues a notice in those proceedings. Once a notice is issued, the court also issues summons in a suit. So the plaint is then registered as a suit. The summons are then sent to the defendant. From the date the defendant or the opposite party receives that summons, their timeline starts for filing the written statement. Now that timeline is 30 days. The court may at its discretion condone the delay and extend it to 120 days. So from the date of service of summons on the defendant, you have a period of 120 days within which the defendant is mandatorily obligated to file its written statement. That written statement becomes the defendant's case before the court as a rebuttal to what you have placed before the court for its consideration. There are judgments of the Supreme Court now that have settled the position that beyond this period of 120 days, no further delay can be condoned. The timeline for filing a written statement cannot be extended. So what have we looked at so far? We have looked at the stage of filing a plaint, then the defendant files its written statement. Where do we head from here when we are talking about a suit under the Commercial Courts Act? Along with the when you file the plaint and the written statement is filed, there is also a requirement to file an affidavit of admission and denial. Now, what is an affidavit of admission and denial? When the plaintiff furnishes certain documents, when you make out your case, you file a plaint, you also attach a host of documents which are your evidence before the court in support of your case. The onus then lies on the defendant to file an affidavit of admission and denial where he either admits to those documents or he denies those documents. He admits that he has knowledge of those documents or he denies that he has no knowledge. Or he admits that he has knowledge of the document but denies the contents that are stated therein. So that is as far as admission and denial of documents go. So once this has been filed by the defendant, what is the plaintiff required to do? The plaintiff is then required to file what is known as replication. Now, replication is whatever the case that the defendant has made out in its written statement. As a plaintiff, you need to rebut each and every one of those assertions that has been made. Please remember that under the Civil Procedure Code, unless every averment made in a written statement is specifically denied, it may be argued that it is a deemed admission on the part of the plaintiff. So it is obligated when you are drafting your replication that each and every averment that has been made in the written statement by the defendant needs to be rebutted. And even the plaintiff is required to file an affidavit of admission and denial of the defendant's documents. So the documents that is filed by the defendants along with the written statement as evidence of its own case, as a plaintiff, I am required to either admit those documents or deny those documents in the same manner. So now we filed a plaint, there is a written statement on record, there is an affidavit of admission and denial on the part of the defendant, and there is a replication and affidavit of admission and denial on the part of the plaintiff. Where does the suit proceed from here? The suit then proceeds towards what is known as inspection, and there is a period of 15-day window that is available. During that period, you can inspect the records that are already existing with the defendant. The defendant can similarly also examine the records that exist with you. Once that phase ends, once the phase of inspection ends, we then move to another very interesting facet, that is organizing a case management hearing. Now, what is a case management hearing? Once the pleadings are on record before the court needs to decide in what manner trial in the suit should proceed, because both the parties by now have filed their documents. Now those documents needs to be examined of whether they support my case to the extent that either party claims that as it does, including where the authenticity of those documents may be in question. So there needs to be oral evidence that is led and trial needs to proceed. So that is the purpose of the first case management hearing. In the first case management hearing, there are issues that are framed, the issues that are required to be decided for determination of the case at hand. Those issues are framed by the court. A timeline is set out then for filing of witness statements by the plaintiff and witness statements by the defendants. Now, what are these witness statements? Let's examine what the Commercial Courts Act says about that. When I file my plaint and I put documents in support of my plaint, there are individuals within the organization of the plaintiff who have either personal knowledge of those facts or have knowledge of those facts of what are stated in the plaint based on the records of the plaintiff. So those need to be asserted by an individual who can lay testimony to those facts. So the witness statement, the format of a witness statement is also now prescribed under the Commercial Courts Act. Beyond the standard procedures of each fact being stated in a different paragraph, each assertion being part of a different point, there are certain other mandatory requirements that has been prescribed. If I am relying on a particular document in my witness statement, I need to refer to that document as it was filed with the plaint. When I am making certain assertions, my witness statement can't be a cut paste of the entire pleadings. It can't be a copy paste of the entire pleadings. I need to make out the same case that is made in the plaint by actually demonstrating the documents as to what they say, as to what may be within my personal knowledge in furtherance of the case, or which may be my knowledge based on the records of the company. Now, whenever any factual assertion is made, I need to also state in my witness statement whether that knowledge of me as an individual is derived from my personal knowledge or is it derived from the records of the company. So that's the framework of the witness statements. Now, once the witness statements have been filed, the court then formulates the schedule, or it may even be contemplated within the first case management hearing for how examination of witnesses are supposed to be conducted. Then we move on to that very interesting phase of trial where witnesses are examined. So at the first instance, the plaintiff will put forth his own witnesses who can support his case. Those are examined by the defendant's counsels. Then the defendant puts forward his own witnesses who are again cross-examined by the plaintiff. Once evidence is led and the stage of evidence is closed, we move to the final leg in a suit. So by now the court has the plaintiff's plaint, it has the written statement, affidavit of admission and denial by both the parties, it has the witness statements of the parties, it even has the evidence that has been led by the parties and the cross-examination records before it. So all that remains is for one last stretch in the suit. That is, the plaintiff needs to have one or as the court may deem necessary, the session for closing its final arguments in the matter, where you finally argue what your case has been. You show to the court from your own records, from the records of cross-examination, as to how your case is entirely made out. The defendant also has an opportunity to go for its closing arguments in rebuttal to what you have argued as a plaintiff, and follow the same procedure. This is as far as the suit proceedings go. Once final arguments in a suit are done, the court reserves its judgment in the matter, and then a judgment is eventually delivered, which operates as the decree of the court in that suit. And then, of course, the onus lies on either party onus lies on both the parties to accept the judgment of the court, or if either party is aggrieved, to move to an appeal.